All right, so we are going to talk about Chapter 1, which is the introduction to the legal system of the United States. And I know that introductory chapters sometimes get treated like, the quote unquote easy chapter in a course. But I actually think this is one of the most important chapters that we're going to cover all semester. And it's because everything else in criminal law and procedure builds on the concepts that we're going to discuss today. So like before we can understand an arrest or a search or criminal charges or constitutional rights, trials, appeals, punishment, or even like the role of police officers in courts, we have to understand how the legal system itself is structured. Okay. So think of it kind of like the foundation of a house. If the foundation is weak, then everything that is built on top of it is going to be unstable. The same thing happens in legal education. So if you don't understand things like federalism and jurisdiction and separation of powers or the role of the courts, then later concepts are going to become much harder to understand. And in this module specifically, we're going to discuss federalism, dual sovereignty, jurisdiction, separation of powers, checks and balances, the structure of the court system, judicial review, the difference between criminal and civil law. We're going to talk about theories of punishment, the social contract, and even ethics in the legal profession. And throughout this whole entire lecture, I want you to kind of think about one major question, and that is, why is the American legal system designed the way it is? Okay? Because almost every structure that we discuss exists today because the founding fathers feared concentrated power. That fear shaped the Constitution, it shaped the court system, criminal procedure, and ultimately, constitutional rights. So let's dig in, and we'll start with federalism. All right. Now, we kind of begin where it's defining federalism as a system of political organization that's involving two or more levels of government, okay? And that definition sounds simple enough, but federalism is actually one of the defining features of the American legal system. So federalism refers to that division of power between the national government and the state governments. And the founders intentionally created this system because they feared that centralized government. So remember, the United States had just fought this revolution against the king, and the colonists believed that too much concentrated power led to tyranny. Okay, so when they designed the Constitution, they intentionally divided the governmental authority. All right, and that division is sometimes referred to as the vertical division of power. The federal government sits above the states in certain areas, but the states still retain their independent authority. And that's extremely important because students often mistakenly assume that states are simply kind of like subordinate departments of the federal government. And that's not true. All right. States possess sovereign authority themselves as well. And that means that they maintain independent powers in many areas unless the Constitution specifically gives authority to the federal government. So that's why laws can vary dramatically from one state to another. For example, criminal sentencing laws differ. Look at marijuana laws. Those differ. You have family law, firearms regulations, educational standards, even healthcare regulations, they differ. And federalism is what allows the states to function more like laboratories of governments. Like one state can experiment with certain policies while another takes a completely different approach. And that creates an ongoing tension in America because people disagree about how much authority the federal government should possess compared to the states. Some believe that stronger federal authority creates the consistency and protects the rights of the people more effectively. Other states believe that they should possess maximum independence because local governments better understand local needs. And that debate has been what has existed since the very founding of this country. All right, so dual sovereignty It means that the federal government and the state governments possess authority over citizens. And that becomes incredibly important in criminal law. So, for example, imagine someone robs a federally insured bank. That single act can violate both the state robbery laws and the federal banking laws. So both governments can prosecute because each government has its own authority from a different sovereign source. Okay. And this is usually where students will go, what, wait, doesn't that violate double jeopardy? And that is a good question. But under the doctrine of dual sovereignty, it doesn't violate double jeopardy because the federal government and the state government are considered separate sovereigns. All right. And trust when I say that this doctrine is controversial. You have critics who will argue that if someone is prosecuted twice for essentially the same conduct, that the protection against double jeopardy becomes weaker in practice. Okay. And supporters will argue that separate governments should retain the authority to enforce their own laws independently. Again, this kind of shows how constitutional law it often involves balancing competing principles rather than producing perfectly clean answers. Okay. Now, the 10th Amendment, it states that powers that are not delegated to the United States by the Constitution are reserved to the states or the people. And that amendment is foundational to federalism. So the Constitution gives the federal government specific enumerated powers. All right. Everything else belongs to the states. And this is why most criminal law is state law. So think about your everyday crimes, your assault, your theft, your DUI, murder, burglary, battery. You know, most criminal prosecutions happen at the state level rather than the federal level. So that's why it's very important. Now, police power does not simply mean police officers. Police power refers to the authority of the states to regulate for the health, safety, welfare, and the morals of society. And that is an incredibly broad power, okay? Some of the things that it will cover will be things like public health laws, your zoning laws, your traffic regulations, licensing requirements, sanitation rules, emergency measures, and criminal statutes, because we can't rule that out. But take COVID-19, for example. You know, during that period, police power became a major constitutional discussion because you had states that were imposing things like lockdowns and mask mandates, and you had quarantine orders and business restrictions and things like that. And you had some people who believed that those measures were necessary for public safety. But you had others who believed that they infringed upon civil liberties, okay? But the debate itself was fundamentally about that scope of police power. All right, so the Constitution gives certain powers exclusively to the federal government, and that would be things like coining money, conducting foreign affairs, declaring war, establishing the post offices, and regulating interstate commerce, right? But one of the most important powers for modern criminal law is the Commerce Clause. And the Commerce Clause gives Congress authority to regulate interstate commerce. Now, originally, the founders probably imagined that this world would involve things like shipping goods between states, right? But over time, the Commerce Clause has been interpreted very broadly. Okay, so today, a lot of the federal criminal statutes rely on the idea that certain conduct affects interstate commerce. For example, internet crimes, drug trafficking, human trafficking, firearms trafficking, wire fraud, organized crime. All those things they can involve interstate activity. Okay, now this broad interpretation kind of dramatically expanded federal power over time. And that expansion created major constitutional debates. Some people argued that the federal government now exercises way more authority than the founders originally intended. And others argued that modern society is too interconnected for states to operate independently when it comes to those major issues. Okay. But again, constitutional law often involves competing interpretations rather than universally agreed upon answers. And if you're taking constitutional law for me this semester or any future semester, you'll see that's one of the main things we dig into. So the Supremacy Clause establishes that the federal law is the supreme law of the land. And that means that where there is valid federal law that is in conflict with state law, federal law is generally going to prevail. Now, notice that I said valid federal law, okay? So the federal government cannot simply regulate anything that it wants to. It still has to act within its constitutional authority. And that distinction matters. So, for example, take modern marijuana laws, which creates some federalism conflicts, okay? Some states have legalized marijuana for recreational use. However, marijuana actually still remains under federal law. So you might be asking, well, how can both things exist at the same time? And the answer is simply federalism's complicated. Okay. So the federal government possesses authority to enforce federal drug laws. But at the same time, states can choose to not criminalize certain conduct under the law. All right. And that's where we start seeing tension that gets created between state autonomy and federal supremacy. I hope that makes sense. Now, the cooperative federalism, this occurs when federal and state governments work together. That would be like a joint task force, homeland security cooperation, maybe an FBI partnership with local police or, drug enforcement initiatives, things like that. But in reality, modern law enforcement often, functions in collaboration across multiple levels of government. So jurisdiction simply means the legal authority to hear a case or to enforce the laws. And state jurisdiction is going to cover most traditional crimes, which are going to be things like your murder, rape, theft, assault, DUI, gambling offenses, whatever, right? Your federal jurisdiction is going to apply to things that involve, federal officials, property that belongs to the federal government, interstate activity, federal interest, things like that. So like an interstate kidnapping or terrorism or some sort of crime on federal land or crimes involving federal agencies or counterfeiting even, Concurrent jurisdiction is going to exist when both governments possess the authority. And again, this is often what surprises students because we naturally assume one government should probably handle one crime, right? But federalism is what allows for that overlapping authority. All right, so dual federalism views the state and federal governments as co-equals. Hierarchical federalism views the national government as superior. And historically, America has kind of moved between those models over time, depending on, political movements, Supreme Court interpretations, any kind of economic crisis, wars, things like that. So, for example, during the New Deal era, federal authority was expanded quite dramatically. Okay. And that expansion changed how Americans viewed the balance between the state and federal power. All right, so now that we've talked about the state jurisdiction, federal jurisdiction, and concurrent jurisdiction, we need to kind of slow down for a minute and look at the bigger constitutional disagreement underneath all of this. And the real question is not like which government can prosecute this case. We're looking at a deeper question, and that is how much power should the federal government have compared to the states? All right. And that question has shaped American law from the beginning, and it still shapes, criminal justice today. Now, one way to understand the debate is through the idea of dual federalism. And dual federalism gives the federal government and the state governments, it views them as separate but equal authorities. And they are separate but equal within their own spheres. So under that view, the federal government should handle national concerns, and states should handle local concerns. Okay. So the 10th Amendment becomes very important in this model because it reminds us that powers not given to the federal government are reserved to the states or to the people. So under the dual federalism approach, criminal law should remain mostly a state issue unless the Constitution clearly gives the federal government authority. Now that makes sense when we think about like traditional crimes like murder, robbery, burglary, assault, DUI, things like that. Those crimes usually happen within one state and involve local victims, local police, local prosecutors, local courts, those kinds of things. So under dual federalism, those are exactly the kinds of issues that states are supposed to handle. Now, contrast that with the hierarchical federalism. And again, that views the national government as superior when federal authority exists. So that view relies heavily on a more broad interpretation of federal constitutional powers, specifically within the Commerce Clause and the Necessary and Proper Clause. Now, I already talked about the Commerce Clause a bit, and how it gave Congress the authority to regulate that interstate commerce. And again, at first it sounds like it should only involve trade between the states, but it has begun to be interpreted much more broadly. And that matters because once conduct affects interstate commerce, then Congress has the authority to regulate it. And in modern life, almost everything can be connected to interstate commerce in some way. Think about drugs. A drug offense might happen locally, but the drugs may have crossed state lines or international borders in order to get to where they were. Firearms, you have a gun possession offense that might happen in one town, but the firearm, may have been manufactured and sold in another state. All right. Internet crimes. You may have a person who commits fraud from their bedroom, but the communication, the banking system, the servers, and even the victims can involve multiple states. So this is why federal criminal law has expanded so much. Now, the Necessary and Proper Clause also matters because it allows Congress to pass the laws that are needed to carry out its constitutional powers. So if Congress has authority over interstate commerce, it can pass laws reasonably connected to enforcing that authority. And this is where the debate gets messy. So supporters of more broad federal powers will argue that modern crime is not always local anymore. Criminal activity can involve, like I actually previously stated, drug trafficking, human trafficking. You got terrorism, organized crime. You've got cybercrime. You've got identity theft, interstate fraud. You've got weapons trafficking. You've got crimes that involve federal property and federal officials. And from that perspective, a stronger federal role makes sense because states may not have the resources or the jurisdictional reach even to handle a complex multi-state criminal activity. But supporters of stronger state authority argue that federal criminal law has expanded way too far. Okay, they argue that criminal law was traditionally supposed to be primarily local and that federal involvement can blur constitutional boundaries. So if anything can be connected to interstate commerce, well, then the federal government's powers become extremely broad. Okay. So when we talk about dual federalism versus like hierarchical federalism, we're talking about the competing versions of the American government. So the dual federalism is what's asking us to protect that state independence. The hierarchical federalism emphasizes that national authority where federal constitutional power exists. And criminal law kind of sits smack dab in the middle of that debate, Imagine that you have a robbery that happens at a local convenience store. At first glance, that might sound just like a state crime. Local police respond, local prosecutors charge the case, state laws apply, right? But let's change the facts. What if that robbery did involve a federally insured bank? What if that defendant crossed state lines afterwards? What if the weapon used was illegally transported through interstate commerce? What if the robbery was connected to a larger organized crime network? Suddenly, federal jurisdiction can appear. All right. And that's why jurisdiction is not just about geography, it's about legal authority. So, as future legal professionals, you need to be able to ask, who has the authority to act here? Is this purely a state matter? Is there a federal interest? Is there concurrent jurisdiction? And if both systems can prosecute, why might one system take the case instead of the other? All right. Federal prosecutors can become involved when a case has national significance, when it crosses state lines, when it involves federal agencies, if it involves federally protected interests, or it carries penalties that are unavailable under state law. So state prosecutors can handle cases that are more local, even if the conduct is serious. And the bottom line is that neither system is automatically better. They just they gain their authority from different sources. All right. This is why also federalism is not just like some abstract constitutional concept. Like, it affects real defendants, real victims, real prosecutors, real case strategy. All right. So the same act can lead to different charges. It can also lead to different sentencing exposure, different plea negotiations, even, different correctional systems, depending on whether or not their case is handled, federally or by the state. All right. But bottom line here is that federal and state criminal jurisdiction, they exist within a constant constitutional tension. So again, you've got your dual federalism that's intended to protect that state authority, the hierarchical federalism, which is going to emphasize federal supremacy where that constitutional authority exists, and modern law often operates somewhere in between. Okay, especially when state and federal governments share jurisdiction over the same conduct. Now, one of the most important structural principles in American government is the whole concept of the separation of powers. Remember that the founding fathers were deeply afraid of this concentrated authority, right? They believed that if one person or one branch controlled too much power, then individual liberty would eventually disappear. So instead of creating a single all-powerful government body, they divided it, among three branches: the executive, the legislative, and the judicial. And each branch has a different function. And it's important because oftentimes people think that the government is just kind of one, giant system operating together seamlessly, and that's just not the case. In reality, those branches often compete with one another, and they disagree with one another, and they do limit one another's power and authority, but that conflict is intentional. And the executive branch, for example, is responsible for enforcing the laws. So at the federal level, that's going to include the president, the federal agencies, and all the executive departments. So when we think about criminal law specifically, the executive branch is going to include your three-letter agencies: your FBI, your DEA, your ATF, your DOJ. You've got Homeland Security, you got your federal prosecutors, things like that. At the state level, your governors and state law enforcement are going to fall within the executive branch. Okay. I know that prosecutors are often assumed to be a part of the judicial branch because they work in the courtrooms, but they're not. Prosecutors are actually executive branch officials because they're enforcing the laws. So the legislative branch, they create the laws, and at federal level, Congress is going to have your House of Representatives and your Senate. Your Congress is going to create your statutes, and the state legislatures are going to perform that same function at the state level. Now, the judicial branch is going to interpret laws through the administration of justice. So, courts are going to be able to determine what a law means, whether the laws are constitutional, whether rights were violated, whether legal procedures were properly followed, things like that. Okay. Now, I want you to notice something very important here. The judicial branch does not create laws in the same way that Congress does, but judicial interpretation can kind of dramatically shape how laws operate in practice. And that's one reason the Supreme Court appointments become so politically intense. Judges influence constitutional interpretations for generations to come. All right, so now let's talk about checks and balances. These exist to prevent any branch from becoming too powerful, or at least it's supposed to, because that's a whole other debate that we can get into. But again, it was intentionally designed to slow government down. The founders believed that concentrated power created danger. So each branch possesses tools to limit the others. So, for example, the president can veto legislation. Congress can override that veto. The Senate confirms, judicial appointments, and courts can declare laws unconstitutional. So, and sometimes you'll have people who become frustrated with how slow the government operates, but the slowness, again, is partially intentional because it was designed to force compromise and to prevent a rapid concentration of power. Okay. Then we have judicial review, and that's the authority of the courts to invalidate government actions that violate the Constitution. All right. This is one of the most significant powers in the American legal system. So think about how enormous this authority really is. Like unelected judges can invalidate actions that are taken by Congress and presidents and governors and legislatures and executive agencies. And then that creates ongoing debates about judicial power because some people view judicial review as essential to protecting constitutional rights, whereas others will argue that it gives judges too much authority over the democratic processes. So that tension, it's essentially existed since the beginning of the republic. By the way, I hate that I don't have my professional microphone, so just bear with me on this. All right, let's talk about the court system. So it's extremely important because, again, you are students in legal studies. And honestly, a lot of people who come into it with an understanding of the courts based on lived experience, which is very situation kind of oriented, or very television movie based understanding of it. So you'll have people who often imagine things like these dramatic objections and surprise evidence and emotional confessions and, nonstop jury trials. But in reality, most cases never actually reach a full trial. But understanding that court structure is still very much foundational. So we have trial courts first, and these are the ones that are going to hear the evidence and they're going to determine facts. So this is where we have witnesses testify, evidence gets introduced, you have juries go and deliberate, you have verdicts that are rendered and sentences that are imposed, okay? Then you have trial courts who are also the fact-finding courts. So, for example, these are going to be your state superior courts, your federal district courts, any kind of local municipal courts, things like that. One thing that is often misunderstood is that trial courts are not primarily deciding any kind of like broad constitutional philosophy, right? They are focused simply on evidence and procedure, credibility, an application of law to the facts, right? Then we have the appellate courts, and they review the decisions that are made by the lower courts. And this is very different from a trial. You don't have witnesses that testify. You don't have evidence that gets introduced. They simply review. They review for legal errors and constitutional violations and interpretation of the law. And this is one reason that appeals are so difficult, because a defendant can't simply say, like, I don't like the outcome. So I need it to be, I need you to check it. There has to be a legal basis for the appeal. So when they do review it, they can affirm the decision, they can reverse the decision, or they can remand the case back to the lower court. And a remand means that the case is returned to the lower court for some sort of further proceedings that are going to be consistent with the appellate ruling. Then we have the inferior courts, which have a limited jurisdiction. These are going to be things like your juvenile court, your municipal court, probate court, magistrate court, traffic court, things like that. And they are called, they're not courts of record, meaning that there's no formal transcripts or anything like that that get taken during the course of a hearing. Now, the Supreme Court is the highest court in the United States, and there's very few cases that this court actually hears. They do receive thousands of requests every single year, but they only take a very, very small percentage. And that's because the court is not designed to correct every legal error that happens in America. Okay. Instead, it's supposed to focus primarily on things like constitutional interpretation, major federal questions, conflicting appellate decisions, and any kind of nationally significant legal issues. Now, the Supreme Court has enormous influence, and that's because its decisions become binding precedent. All right. Pause there for a second, because precedent is one of the most important concepts in law. And precedent means that prior judicial decisions guide future cases. Okay? That creates consistency and predictability within the legal system. So, for example, once the Supreme Court interprets a constitutional right, then lower courts have to generally follow that interpretation. That's why landmark Supreme Court cases shape American society so dramatically. Now, just in case there's any kind of confusion, because we do have these, two parallel court systems, the state and the federal, most criminal cases are going to happen in state court. Federal courts are generally going to hear cases that involve, constitutional issues, any interstate matters, any kind of dispute that's involving federal law, and then, of course, federal crimes. So this is going to become important later when we start discussing constitutional rights, because many criminal procedures issues eventually do move through those systems through the appeals and through a habeas corpus, petition. And habeas corpus is an extremely important constitutional concept. It literally means you have the body. Okay, so a habeas corpus petition challenges unlawful detention or imprisonment. Okay, and historically speaking, habeas corpus protections were considered essential safeguards against any kind of government abuse. So without judicial review of detention, governments could imprison people indefinitely without any kind of accountability. So that's why this protection remains kind of central to constitutional liberty today. Now, people often wonder why circuit courts matter so much. And the reason is that different federal circuits sometimes interpret laws differently. So, for example, one circuit may interpret a constitutional issue one way, while another circuit interprets it differently. And that creates what's known as a circuit split. And circuit splits are one of the major reasons that the Supreme Court actually agrees to hear cases. They will step in to resolve any kind of inconsistent interpretations across the country. Again, it's aimed to kind of maintain some national consistency when it comes to federal law. And honestly, I would say it demonstrates something important about law in general, and that is that law is rarely static. The legal interpretation is evolving constantly. You have courts that are debating, meanings. You have judges that are disagreeing with each other, and precedents change and society changes. And I firmly believe that the law is living in the sense that interpretation evolves over time, even when constitutional text itself remains the same. All right, so some think that courts simply exist to punish people or to settle disputes, but the judicial branch actually performs a few very critical constitutional functions. So, one of the major responsibilities of the judiciary is the administration of justice. And the phrase sounds very simple, but it does have like a big meaning. So the courts act as kind of the mechanism through which disputes are formally resolved according to the law. That includes, your criminal prosecutions and then everything that falls under civil, family law, probate issues, all those things. Then you have constitutional questions, administrative disputes, things like that. So judges interpret statutes, they apply precedent, they determine whether or not procedures are followed correctly, and they're supposed to ensure that constitutional protections are also upheld. Now, ideally, courts are supposed to function as neutral arbiters, which means that judges should not act as advocates for either side. Instead, they're supposed to ensure that there is fairness and proper application of the law. So whether or not courts always achieve neutrality is heavily, debated. You have critics that will argue that things like politics and judicial philosophy and racial disparities, socioeconomic inequalities, and even access to legal resources can all affect the outcomes within the legal system. Okay. And honestly, those are extremely important decisions or conversations that need to be had because the law itself doesn't operate in a vacuum. It reflects the society that is operating around it. Now, slide also talks about the judicial branch being independent, which is true, but it does still work alongside the executive branch in criminal matters. And that's important because courts rely on prosecutors and law enforcement and correction systems and clerks and probation officers and attorneys. And the system, the criminal justice system itself is very highly interconnected. So, for example, you'll have a judge who might issue a search warrant, and the law enforcement executes the search warrant. And prosecutors decide whether or not they want to present charges, and defense attorneys would challenge evidence. And then courts would essentially determine, maybe the admissibility of that evidence. But each part of the system affects the others. All right, so now we need to talk about one of the most important constitutional law cases in American history, and that's Marbury versus Madison. And that is a case that every law student eventually is going to encounter because it establishes the principle of judicial review. Now, before this case, the Constitution did not explicitly state that courts could strike down laws as unconstitutional. That authority had to be established through interpretation, okay? So let's back up and talk about the historical context so it'll kind of help make the case hopefully more understandable. But the election was very politically intense. President John Adams and the Federalists were losing power to Thomas Jefferson and the Democratic Republicans. So before leaving office, Adams attempted to appoint several judges who were known as the Midnight Judges, okay? And one of those appointees was William Marbury. However, Marbury's commission was never delivered before Jefferson took office. All right. And Jefferson instructed James Madison, who was the Secretary of State, to not deliver it. All right. Marbury turned around and sued, and he asked the Supreme Court to force Madison to deliver the commission. Now, this is where we have Chief Justice John Marshall do something incredibly creative and strategic, okay? Because he realized that if the court ordered Madison to deliver the commission, Jefferson was likely going to ignore that order, and that would make the court appear weak. But if the court refused entirely, it would also appear weak. So he came up with this compromise. And he ruled that Marbury does deserve that commission, but the section of the Judiciary Act that gave the Supreme Court the authority to issue the order was unconstitutional. And with that decision, the court established its authority to declare the laws unconstitutional. That single decision fundamentally reshaped American constitutional law. Now, pause for a second and kind of take that in, like appreciate how significant that power actually is. Because judicial review means that courts can invalidate laws, executive orders, policies, and even governmental conduct if they find that it violates the Constitution. And that's a huge amount of authority, okay? And that power, of course, does still continue to generate a lot of controversy today, because some people believe that judicial review, um, that it's essential to protecting, minority rights and constitutional freedoms. But then you have people on the other side who say, no, 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 we're giving these unelected judges too much power over democratic government. So again, constitutional law is filled with so many competing perspectives, and that is exactly what we focus on in the con law class. All right, so sometimes people confuse the systems because they involve courts and lawyers and judges and legal disputes and all kinds of things. But the purposes of both criminal and civil law are very different. Criminal law involves the government prosecuting individuals for violations of criminal statutes. All right, so the goals are going to be, punishment and deterrence and incapacitation and rehabilitation, whereas civil law is going to focus on disputes between the parties. And the goal is typically going to be compensation or equitable relief rather than punishment. Courts love to order monetary damages over anything else because it's easier. Um, so, for example, if someone assaults another person, two completely separate legal cases can come out of that. So you can have the government who files charges for assault or battery, but then you also have the victim who can sue the offender for damages. All right. And that distinction becomes important when discussing the burden of proof. In criminal law, it's beyond a reasonable doubt, and that is the highest standard of proof in the legal system. And why is that? And it's because liberty's at stake. Somebody can lose their freedom, their reputation, their voting rights, employment opportunities. They can even lose life itself if it's a capital punishment case. And because the consequences are so severe, the burden of proof is intentionally high. Okay. Civil law, though, uses a lower standard, which is the preponderance of evidence. And that means that it's just more likely than not. All right. So, you might hear it described as like 51%. Okay. Now, obviously, real trials are not mathematically calculated in that way, but the idea is that the plaintiff just has to show that the claim is more likely true than false. All right. So that lower burden exists because civil cases generally just involve money or remedies rather than incarceration. Um, and of course, with the burden of proof in criminal cases, the government is the one who bears that burden of proof. And that's an extremely important constitutional principle. Defendants are presumed innocent unless they are proven guilty. So the prosecution has to establish that guilt. The defendant is not required to prove anything. All right. That's why you'll see a lot of people who don't even take the stand in their own defense, because again, it's up to whether or not the state has proven their case. And this principle is, it's really one of the cornerstones of our American criminal justice system. Now let's talk about this in just a little bit more detail. Civil law does include areas like contract law, tort law, which is your personal injury type stuff, property law, intellectual property, family law, juvenile law, although that has a criminal component as well, bankruptcy. All of those things are going to fall under civil law. One of the most important concepts in torts is going to be negligence. Negligence occurs when someone fails to act with reasonable care. So that's like a car accident. Like if somebody's texting and driving and it caused a car accident, that's negligence. Medical malpractice, slip and fall. You've got negligent security or unsafe premises. Okay. And negligence is not like your intentional torts, even though they're both torts. Negligence does not require intentional harm. okay, like battery or trespass, those do. You can have someone who can be negligent without intending any kind of injury. All right. Go back to the distracted driver who was texting while driving and having an accident. They may not have intended the harm that came from it, but the courts would look at, was their conduct basically unreasonable, and did that create the liability? All right. It also talks about strict liability torts on here. Strict liability means that liability can exist without intent or negligence under certain circumstances. And like you might have a dangerous activity that creates like an automatic responsibility because society considers the risk to be so unusually high. That would be like if you're out, blowing up explosives on your property, you're responsible for whatever happens. Okay. Now, a key distinction: plaintiffs sue defendants in civil cases. All right, so it's individuals or entities versus individuals or entities. The government sues on behalf of the state because they see the state as being wronged in these particular matters. Okay, so they prosecute in that sense. So again, representing, the society collectively, in a way to condemn conduct that's considered harmful to public order versus, private individuals or entities seeking, some sort of remedy in civil law. Now, this section kind of touches on a major philosophical question, and that is, why do societies punish people? And it might sound obvious at first, because somebody broke the law, right? But criminal justice philosophy goes deeper than that. And the first theory that it has on here is specific deterrence, all right? That focuses on preventing the offender from committing future crimes. So the idea is essentially, if punishment is so unpleasant, the offender will avoid repeating the behavior. For example, someone convicted of a DUI can face, jail, fines, probation, license suspension, mandatory treatment, things like that. And the hope is that those consequences are strong enough that they will discourage somebody from repeating this again in the future. All right. Next one is general deterrence, and that focuses on society as a whole rather than the individual offender. So the idea is that the punishment discourages others from engaging in similar behavior. Okay, so for example, you might have a very high profile case that is intended to serve as a warning to the public, right? Now, whether or not it actually works is very heavily debated. And some suggest that, certainty of punishments deters more effectively than severity of punishments. So in other words, people are often more influenced by the likelihood of getting caught than by the harshness of the sentence itself. And then you have incapacitation, which prevents, offenders from committing crimes by physically restricting their freedom. So that's jail, prison, house arrest, execution, whatever. Jail being a place where you typically go for under a year, prison for over. But this theory focuses less on changing behavior and more on limiting opportunity. If someone's incarcerated, they obviously cannot commit crimes against the general public while confined, or at least they're not supposed to be able to. But of course, you have critics that will also point out that incarceration alone doesn't, necessarily address the underlying causes of criminal behavior. Rehabilitation is going to focus on changing offender behavior. And the theory there assumes that criminal behavior can sometimes be addressed through things like education, counseling, treatment, therapy, vocational training, substance abuse programs, or even like a mental health intervention. But the basic idea is that punishment alone may not solve that underlying cause of criminal conduct. So, for example, if someone commits crimes because of an untreated, drug addiction, Simply throwing them in jail without any kind of treatment may not actually reduce future offending once they're released. All right. In the same vein, if someone lacks education or employment opportunities or stable housing, then those issues can contribute to recidivism. And recidivism refers to repeat offending. And one of the biggest modern criminal justice debates involves whether or not the system focuses too heavily on punishment and not enough on rehabilitation. Some believe that rehabilitation reduces long-term crime rates and improves public safety more effectively. Others argue that certain offenders pose ongoing dangers, that rehabilitation efforts are sometimes ineffective. Okay, so again, criminal justice often involves, trying to balance public safety, accountability, fairness, and social policy. And then you have retribution. And retribution is society's way of expressing a moral condemnation for wrongdoing. So it's basically like saying people deserve punishment because they committed a wrong. All right. And the difference between retribution and deterrence is that retribution is not focused on preventing future crime. It focuses on moral accountability. The punishment itself is viewed as justified because the offender deserves these consequences. And this idea has very deep historical roots. In older legal systems, punishments often centered around concepts like vengeance and balance and moral repayment. Modern legal systems, though, generally reject any kind of personal revenge in favor of, state-controlled punishment. But these ideas of retribution still very strongly influence criminal justice today. So, for example, let's say that there is a particularly violent crime. Well, public discussion often focuses on whether or not the offender deserved a severe punishment, right? That language reflects that retribution like thinking. And honestly, many criminal justice policies involve multiple punishment theories operating kind of simultaneously. So a prison sentence can punish, it can deter, it can incapacitate, and it can attempt rehabilitation all at the same time. Now, the social contract is more philosophical than some of the earlier material, but it's incredibly important because it helps to explain why governments kind of exist in the first place. Social contract theory proposes that people voluntarily give up some freedoms in exchange for order and protection. So without government, society would exist in what philosophers sometimes describe as a state of nature. All right. So the concern was that complete freedom without rules eventually creates instability, violence, and insecurity. All right, so people enter into kind of a societal agreement. The government is going to agree to provide security and protect rights and maintain order and resolve disputes. In exchange, citizens agree to follow the laws and surrender certain freedoms. Now, this does raise a constitutional question of how much power should the government possess before liberty becomes threatened? And that question sits at the center of constitutional law. Um, so let's talk about these, zones of freedom where the government authority is limited. Those protections are known as civil liberties, and those are going to include things like freedom of speech, freedom of religion, protection against unreasonable searches and seizures, due process, the right against self-incrimination, the list goes on. Okay. Now, what is very important to understand is that the rights are rarely absolute. Okay. So many people believe that constitutional rights function like these unlimited permissions, but these rights involve balancing tests. So, for example, free speech protections are broad, but not unlimited. So, certain categories of speech receive reduced constitutional protection. All right, in the same way that privacy rights exist, but courts also balance governmental interests such as like public safety and national security, and even law enforcement's needs. So constitutional law often becomes a constant balancing act between liberty and governmental authority. So, as populations grow and societies become more complex, government involvement typically expands. So, think about modern society compared to, say, the 1700s. Today's government is going to regulate things like transportation, communication, healthcare, digital privacy, banking, workplace safety, food standards, aviation, cybersecurity, environmental safety, and a whole ton of other areas. And as government expands, we have concerns about civil liberties that also expand. For example, modern technology has created constitutional questions that founding fathers could have never imagined, like cell phone tracking, or social media surveillance, or facial recognition, or GPS monitoring, or artificial intelligence, or even just digital privacy in general. They all raise constitutional concerns regarding governmental authority. And honestly, that kind of demonstrates something important about constitutional interpretation. And that is that the Constitution itself remains relatively short and unchanged compared to modern society. But courts continually, reinterpret constitutional principles to address these evolving technology and social conditions. And that's one of the reasons that constitutional law remains so dynamic. All right, so this is the last slide, and I'm going to cover the ethical considerations and kind of wrap up some thoughts. So just bear with me. And by the way, I am so sorry that I don't have my professional mic all set up. I will have to re-record these at some point, but thank you for bearing with me. Okay, so ethics. This is one of the most important topics in the entire legal profession. And that's because the legal system depends heavily on trust and professional responsibility. Attorneys have ethical obligations that are governed by the bar associations, the disciplinary authorities. You've got the professional conduct rules, things like that. And violations can lead to things like sanctions, suspension, disbarment, things like that, right? And, you know, sometimes people think that ethics only involve like obvious misconduct, like stealing a client's money or lying in court, but the ethical obligations are much more broad than that. Okay. Attorneys have to also address issues that involve things like confidentiality, conflicts of interest, competence, communication, candor to the court, and fairness toward opposing parties. So, for example, a defense attorney may know damaging information about a client, but it's still, they must maintain confidentiality under those ethical rules. But at the same time, attorneys cannot knowingly present false evidence. So those situations kind of create some ethical tension at times, if that makes sense. Now, paralegals have ethical obligations as well. And one major issue involves the unauthorized practice of law. Paralegals cannot independently provide legal advice in the same way that attorneys can unless it's been permitted by a state, which is not in Georgia. And that distinction is important because paralegals typically will work under attorney supervision and play an essential role within the legal practice. But again, there's ethical boundaries regarding independent representation and legal counseling. Now, with law enforcement, um, you have unethical conduct by police officers that can, violate constitutional rights. It can absolutely destroy a wrongful, a criminal prosecution. It can create a wrongful conviction. It can undermine public trust and create, civil liability. So some examples like that would be like falsifying reports, unlawful searches, evidence tampering, coercive investigations, or even Brady violations that involve, suppression of what's considered exculpatory evidence. But I know I'm probably getting way ahead, but I'm going to give you a little like bit on the Brady violations, because it's a really, really important concept, that you definitely will encounter later on. But under constitutional law, prosecutors have to disclose exculpatory evidence to the defense. Exculpatory evidence is the type that is favorable to the accused. Okay. Failure to disclose it violates due process. And unfortunately, history contains many, many wrongful conviction cases involving suppressed evidence and or unethical conduct. Okay. That's why ethics are not simply a professional suggestion. All right. They do affect liberty and fairness and constitutional rights and public confidence in the judicial system in general. Just remember that in these cases, you're never supposed to get to court and there be like an aha, a smoking gun or anything like that. It's just not supposed to work that way. And ethics kind of remind us that legal power carries enormous responsibility. It just does. Um, and that's pretty much all I'm going to say about any of this. As we continue going through the remainder of this course, I want you to continue asking several important questions. Who possesses authority in the situation? What constitutional rights might have been, implicated? Which court would hear this matter? And what governmental interests are being balanced? Okay. Actually, you know what? I would also add in what purpose is the legal system attempting to achieve in this? And is justice actually being served? Because understanding the law is not simply about memorizing statutes or procedures, it's about understanding how power operates within society, how rights are protected, how legal systems affect real human beings. And those questions are going to follow us for the entire semester. And that's it. Please reach out and let me know if you need anything. Bye.